One thing is abundantly clear about family courts in this country. There's a disconnect between help for families, keeping the kids connected, and the need for other than family members to make their decisions for them. Child dysfunction is on the rise. Common sense would be that resolution is best had through peaceful negotiations where possible. The courts cannot always do that, nor can they do more than sometimes just reduce the family's resources from experience. Simply put, families are getting destroyed in family courts, and hopefully today my guest will help us expose the situation and hopefully talk about it and make sense out of this. And I have with me to talk about it on my immediate left, Sandra Radna from radnalaw.com.
Yes.
And to her left, Jeffrey Bloom, who's a Mediator radio talk show personality from MyMediationServices.com. Okay, welcome. Let's see. Starting off, the family as a institution, and the institution of family through divorce has broken down naturally without having any knowledge of where the court existed or what other ramifications or what other choices we may have in settling a dispute, like in mediation or collaborative law, whatever it might be. Do you have a feeling about that in either case, about how things have trended? Either one of you.
Well, I would just say that it's become more acceptable to get divorced. It's more acceptable to have children without getting married. Children suffer the consequences of divorce no matter how smoothly it goes. It's always best to resolve it and keep the children out of it.
Yeah.
But where we are right now is that there are a lot of children of divorce, and there are a lot of people going through the process, and somebody like Jeff can maybe help the process be more streamlined and protect the children because they don't go through what happens in a contested divorce, a highly contested divorce.
You know, when you said the words, when you said the acceptable, that divorce is becoming acceptable, part of our things is divorce culture. I've always said that we're in a divorce culture. We don't really belong here, but that's where we are.
Well, I think one of the reasons for that is with the no-fault divorce, that New York was the last state, right, to become no-fault divorce state in October 2010.
Right.
So now it's easier, whereas sometimes couples would have put it off because one had to take the blame prior, or take the fault, for lack of a better term. Now they don't have to do that anymore. So one party says there's an irretrievable breakdown of the marriage for 6 months or longer. The other partner agrees, and as long as they have all the ancillary issues, child support, and marital home, and assets, and joint debt, and everything worked out, you file with the court, there's no appearance in court, and you're done.
Yeah.
So it's easier now.
Certainly. I'd like to know, especially from your perspective, what would be some of the reasons why a family might be better in court, as you were suggesting in our commentary before the show started?
Well, there's certain reasons why you would want to go to family court, and certain reasons why you'd want to go to Supreme Court. Supreme Court is where you have to start a divorce action. So if there's a divorce action, you have to start in Supreme Court. There's no choice. Mm-hmm. That's the only place that hears it. But there's other family-related issues that would happen in family court. So, for example, if the couple had not been married and they had a child together, they would go to family court, not Supreme Court. Also, if you're already divorced and there's post-divorce judgment issues that arise, usually every divorce agreement or every divorce decree gives family court concurrent jurisdiction with Supreme Court, which means that you can go to family court to resolve your matter. And the reason that is a good thing is that Supreme Court usually takes much longer. Family court, the way they have it divided up, you'll have a judge that just deals with support. You'll have a judge that's just dealing with visitation. You have a judge that's just dealing with neglect. So what happens is you might get your relief quicker because you have that one judge dealing with it. You'll get your court appearance right away. The downside of it is that if it becomes very entrenched in what happened in the prior part, which maybe the divorce judge would have that information, not necessarily a family court judge, you wouldn't have the context that you need, possibly, and that's why you would go back to Supreme Court. So it's a fine line of where you're going to go. But
I have to apologize. You know what I said, family courts, we tend to do that in a general sense that we see from sociological perspectives, especially that a family is going to a court. So in our minds, we really mean Supreme and family court.
Okay.
We mean the contention that could happen in both, the misery that can happen in both, the dysfunction that can happen in both. So we kind of group them together, and that's my bad for not explaining it properly.
Well, in New York, it's divided up, and not every state's like that. Here, we have it specifically divided up between Supreme Court and family court. But yes, people do just call the general area family law.
Yeah, and I got stuck there many times. There's a lot of money to be made in the matrimonial sector. Apparently, approximately 1/3 of the money made by the lawyers in general are made through the family law sector. Why does it matter? Well, it seems that there's, in the contention process, in the contest process, that it's easy to exacerbate and cause litigants to expend more of their resources than they may ordinarily have needed to have spent, without claiming that there's a bad reason for them to be doing this. Nonetheless, we've seen over the years, I'm doing this for 30 years, that there's an awful lot of stories that come to me about those kinds of events, that they've lost all of their money.
And there are good attorneys that will prevent that. That will say, look, we can settle this. You don't have to spend all your money on me and on any other attorney. But there are others, like we discussed in other shows, and I've discussed with Sandra, that will, it's an hourly billing, and there's no incentive to settle, and that's why couples come to us as mediators years later and said, where were you 5-10 years ago? I didn't know mediation existed. I didn't know it was an option. And it's scary.
Jeff, completely, I get that, and I've heard that quite a bit. My question to you would be, how does someone stay healthy in that environment when so much of that, you must really have to work hard at being...
A lot of it is giving knowledge to your client. If the client is not in enough contact with the attorney, that they know what they're supposed to do. So for example, if a client finds out that her husband, or she believes her former husband, was driving under the influence of drugs or alcohol with the children, she may feel justified in keeping the children from seeing the father, from having parenting time. If there is nothing before the court, no motion before the court to make a modification of visitation or to get an order of protection on behalf of the children, if she just withholds that parenting time from the father will be justified in going to court and saying that she violated the court order, and she would be the one that's in trouble. And I'm saying she and he, but it could be vice versa. It could be the mother under the influence.
Because there's no custody law. A good 85% of the parents at home are women taking care of the kids, and they tend to be the custodial parent, which brings up my and Jeff's issue with, do you see that the bulk of our clients get joint custody and the civility within the family is far more intact?
If they can do a true...
The records are showing that the litigated family coming out of divorce has more dysfunction than the kids coming out of the...
We were talking about with the terms, you said custody is like a legal term when you're going through the litigation process. And couples don't like that. Even in mediation, one will say, well, I want custody. And then automatically the other parents, well, I don't want her or him to have custody. That makes me less of a parent. So I like to use more friendly terms, the residential parent. Basically, the children have to have a place where they stay most of the time.
Yeah.
So custody sounds like you're in jail.
It's the same thing with visitation. Visitation is a jail term too.
Right. So
these are all from
plans.
Old English laws.
Right.
Put that on us, and they're still dealing with the situation. It's up to people like us to reform.
And
that's
actually,
what we're
the
doing.
courts have a trend that they don't want to call it visitation anymore. We call it parenting time.
We finally won that.
So yeah.
I mean, it took us like 15 years to get there. We started this a long time ago.
People still forget, but.
But no one's going to give us any credit for this, Jeff. So don't look for any credit.
I made it up. That's why.
I want to talk about something you talked about, access. Let's talk about access. Like getting access is important.
Yes.
That's where we have one of our biggest problems.
One of the biggest issues.
Yeah.
The best way to ensure access for both parents is communication. If the relationship between the two parents is so contentious that they can't talk to each other, if they have attorneys still, they should be talking to their attorneys. So instead of saying, and the attorney, each party needs an attorney that's communicative. So their attorney needs to be able to get back to them. So if there's something coming up tomorrow, the child has a ballet class tomorrow and it's going to be on the other parent's parenting time, but the child really wants to go to the ballet class and they're not answering the text message, a call to their attorney or an email to their attorney, and the attorney saying to the other attorney, they want to go to child's parenting class and you'll make up the day, ballet class, and you'll make up the day, maybe could avoid a lot.
Let me tell you,
that
Sandra,
doesn't always happen.
It's not happening out there. There's more abuses in that area than I was aware of until I've seen it myself.
Well, because even the best parenting and the most detailed parenting plans, things are going to come up like that,
Right.
that throw it off. So
But the idea that you have to call your attorney to get access is nuts.
Not always. If the parents can communicate, that's the best situation.
The lawyers
Sometimes
ask you
don't
not to
have that.
communicate with the other side.
Well,
I mean, that does happen.
That happens
most of the
sometimes
time.
if it's so contentious. If there's an order of protection in place between the two, then you have to do it that way. If no matter what happens, if one parent says, I want to do this, and the other parent always says no, knee-jerk reaction, no, then you have to go through the attorneys. It's not the best way, but it's a way to maybe diffuse a very volatile situation and maybe get a result.
Let's do a little rapid fire like we're doing now, because we're doing just fine. But the relocation issues, I want to make sure I hit them, because this is an interesting combination. We haven't done this too often, having a lawyer and a mediator together in the same panel. Relocation is a big issue.
Yes.
Do we, as mediators, have an issue with relocation?
It comes up in the mediation. Sometimes it doesn't, but if it does, or if it does, actually, let's backtrack a little bit. If it doesn't, I bring it up because it's something that's got to be covered. So the relocation is, if...
Do we have very many negatives? I haven't had any hardly
Not
difficult
many.
times with
I've had
access.
a few, but basically, let's say in this case, a mom's a residential parent, and if she's going to relocate, what's his stance on it? Can she go, 10 miles away, 50 miles away? Can she go to another state? The father has a say in that.
Well, mediation, they have the say that I've heard, that I've been hearing, I should say, is a little bit more interplayed with the reality of the other party, with the mother,
They would have
the
to work out
residential
the-
parent. It seems to
Right.
be connected,
Well,
so
if
it doesn't seem to be too big an issue for me.
Well, if there's a parenting plan, and let's just say the mom has to move for whatever reason, and he doesn't really like that, but he decides that's the best, they all decide it's the best for the children, whatever the case may be.
Yeah.
Then they have to work out how the children are going to be with the dad for the summers or Christmas or Thanksgiving or the different holidays. So the mom may agree to pay for their airfare. Everything.
Yeah, that's
in the
all
mediation is
incorporated in it's
Right.
all
That's exactly
negotiable.
right.
It
Yeah.
still makes it difficult, to see it on a regular
It's
basis.
usually not part of the initial mediation, so that's probably why you're saying you don't see it that much, because usually
Right.
initially everybody's planning on staying where they are and staying within the
Their
area.
intention to leave for the most part. You're right.
But what
But
happens
usually
if-
what happens is
We have to be
one
honest
parent
about
loses
that,
a
Jeff.
job, they can't get a job here, they can get a job someplace else, they can get a job in Georgia, so they want to move to Georgia.
Yeah.
They cannot just pick up and move with the kids.
Correct.
They
Right.
have to first make a petition to the court, show there are very good reasons for why, and how is the other parent going to have access once they move. If there's a reasonable plan and a good reason, the court may grant that petition. If the parties agree, the court will grant it. If the plan is that, well, he can come visit whenever he wants, that's not going to be accepted by the court. If you say, I'm going to bring the child 1 week in a month,
Yeah.
every month, and I'll pay for the airfare for the child to get here, the judge might consider that more reasonable if you have a compelling reason to move. It can't just be, I feel like moving. It has to be for a compelling
I'm doing
reason.
it for 10 years so far, and I haven't seen but one case where the relocation issue became an issue after the mediation was completed.
I haven't had one
I'm
after
just saying,
mediation, but I cover it
just
in the
one.
mediation, and I cover it in the agreement.
Yeah, but I mean, you can...
So it doesn't become an issue.
You can become an issue. It can become an issue whether we like it or not. And the enforcement aspect is what I would ask you about, because how often do you get involved in the enforcement aspect of a relocation issue? Oh, he said he wouldn't leave, We agreed he wasn't going to leave beyond 100 miles or 75 miles. And there he is moving to
I
California.
have had post-divorce issues, but not in regards to relocation. So, I mean, I'm sure
Yeah.
it's prevalent, I'm sure it happens.
It's, yeah, it's just not too often.
And they can never just move and do that, because if you just moved with the child without court permission, the other parent automatically gets custody, because you just
I have
tried to
not
frustrate
seen
that.
that. I have
Yeah,
not
that's
seen
what
that.
happens. But it might be that you just didn't see it because they don't come back to
I
you
hear.
after
I
it
mostly
happened
see, and unfortunately, I'm in the place where I hear most of the problems.
in the beginning.
No, I mean, as an
Oh.
advocate for
as an advocate,
reform in this area, I hear the people who have problems. They come to me, what can I do? And those people are out of state and unable to get help, and they leave without permission and
Right.
stuff like that. Let's go back to one more issue here, the equitable distribution issue. Do you have difficulty determining equitable distribution, or either one of you? Or?
Well, so Sandra,
Generally
equitable
speaking.
distribution doesn't necessarily mean 50-50.
That's
Right.
right.
People think that's what it means, and it doesn't.
right.
Equitable distribution in mediation, I'm not talking about litigation, but in mediation is whatever the couple thinks is fair. So you
Right.
can have couples agree to something where you as a mediator say, wow, that's crazy, that's not fair, but if it's fair to them, they agree to it, then that's equitable distribution. In litigation, it's Sandra's job to advocate for her client to get as much of that percentage, right, as possible.
Right. One of the main reasons that you go to litigation is because of equitable distribution. The most common reason that we're going to trial is because one spouse is maybe not claiming all of his income in his tax returns. It's not reflected in his tax returns. The other spouse is claiming that
One wants to
that
protect
spouse
the
is making
petition,
more
the
money than they're
retirement
claiming,
account.
and they want more money
Yeah.
Could be a
because they
business
know that there's
valuation,
more.
you know.
Well, we
If there's
face the
a
same
own
thing.
business, you'd have to do a business
We face the same
valuation.
thing, but our biggest problem, I'm just speaking for him, I shouldn't do that, is one of your issues the controlling aspect to that. For instance, there's a decision between the House and the retirement account.
Well, and then it could be a swap on that. The husband could say to the wife, and it could be like, okay, you can keep the marital home, but I keep my 401k and pension.
Right.
And they could do that in mediation, or
Yeah.
vice versa, or you only get 20% on my pension because I'm giving you the marital home.
Yeah,
or
length of time of marriage, you do that too? I mean, we
There's a
pretty much do
vacation
that.
home.
How
There's
long
a
are they married?
There's
Yeah.
a Disney club. There's,
Yeah.
you have all the assets on a table in front of you, and all the budget and their bills and their income, and they could divvy it up any way they want to.
Mm-hmm.
And it's usually a lot smoother than if there's two attorneys going back and, oh, I'll get you everything, don't worry about it. And any attorney who's worth their salt can't promise any kind of result.
Yeah.
And what's going to happen in court.
Let's talk
nevertheless.
about the nature of that difference. I mean, when you're talking about a court situation where there's an attorney protecting you, the term I've heard used is you have to zealously protect your client. When an attorney is doing that and the other side is another side, in our case, we don't look at it as other sides.
That's right.
There is a issue for, is that an issue? I mean, do you see the big break in the litigation style versus the mediation style? Either one of you can answer.
Well, sometimes you'll get couples that say, well, my girlfriend had a divorce and she had 2 kids also, and this is what she got. Or
Right.
and the same thing with the husband.
Yeah,
And I
yeah.
said, well, wait a second, no 2 cases are alike, and they're not. And even if they are, you never know what's going to happen. If you get to court, which is going to take 2 years if you're lucky, you never know what a judge is going to decide. So let's work on your case here. And you agree with that, Sandra?
That's exactly right. Every
can't go-
case is different. Everybody has a different set of issues coming into their situation that gets them to trial. We take a page from the mediators. We do try to resolve it. 2 attorneys. If we have 2 reasonable attorneys that are trying to resolve it, a lot of times we could whittle away a lot of the issues, so we maybe have just 1 issue going to trial. But if I have an attorney on the other side, or an adversary on the other side that just doesn't want to agree, that's not going to happen. It takes 2 people to agree. So then we may have to litigate everything.
Yeah, that comes against the litigant who's trying to find his answer to the problem, and then he finds it's been taken away from him.
Well, a lot of times it becomes an economic decision. You're trying to get a certain amount of money, but by litigating it for so long, you're probably spending more money than what you're going to get afterwards. Some people get to the point, they say, it doesn't matter. It's just the point of the matter, right? I need to go on. And that's what we do.
The people should know, and the viewers should know, that it's not always their choice. It's not the litigant's choice as to how far a case goes.
That's right, because if you don't have the 2 parties agreeing, if only one of you is saying they want to agree, it's going to continue and it's going to go to trial.
This way, one of the reasons why we chose our field is because we wanted to give the power to the family and who would be making those decisions, to allow them to settle their dispute, find resolution
Absolutely, there's so
within
many
themselves.
extremes like that. And we interviewed somebody a few weeks ago, and also on my radio show. He's been in the divorce process for 10 years. The issue's been over equitable distribution of what is and what's not a marital asset, and he spent over $2 million already in litigation.
Oh my goodness.
And he's had his assets frozen.
Now,
and
the
it's
sad part
craziness.
about that is the kids were older.
Yeah,
Right.
There was really nothing to get except the assets. This really broke our hearts as mediators to see that money go away from the family. It just went away.
It's very
Let's go
often that they are able to resolve the issues of who gets the marital home, who's getting custody or parenting time or residential custody. I don't know, I forgot what the other word was that we were using. But,
he came up with the word.
Residential parent.
residential parent. But equitable distribution becomes the one issue that you can litigate on. And that's, I would say, a great percentage of the trials end up coming on equitable
Yeah,
distribution.
yeah.
Because money becomes the
some
one thing that you
some
can
of
fight
our
about.
most difficult decisions come in that area too, I would think.
Yeah, it
Right?
does.
Yeah. Okay, let's talk a little bit about more money, child support. The Child Support Standards Act has a certain percentage. Let's use the 25% for 2 children on New York State's gross income level.
Right.
We have found, and again, I'm speaking for him, why don't I let you do all the talking,
No, it's-
about the percentages not necessarily being exactly
The advantage
applicable.
of a mediation, and also in regards to the equitable distribution that we were talking about earlier, and the flexibility, same thing with child support. So let's say we use example 25%, and we have 2 parents, and based on their income, the non-residential parent has to pay $1,500 a month, let's just say.
Yeah.
And that's a number. And he says, well, I can't do that. But I'm going to pay for, Johnny's Cub Scouts, Mary's ballet lessons, I'm paying for health care, but I also need to live on my own also, so I could pay $1,000 a month. Let's just say that's a number.
And the wife says that's
And the wife
too
says
bad.
that's fine. The wife says, well, that's fine. We'll do that.
Excuse
And
me.
as long as she could manage her budget and do what she has to do around $1,000 a month, And then in the agreement, in the mediation, you put what the Child Support Standard Act is, why you're deviating, and a court will sign off on it.
Right.
Whereas if you go to the litigation process, you're just going to say $1,500 a month.
Yeah,
He's not going to be able to do it. At some point,
do you
he's
concur
going to
with
breach.
that?
breach
That's
the
true.
contract.
That's true.
That's true.
So he can't pay
unfortunate.
for it. So he'll do it for a few months, maybe a year.
So this is another tool that you have.
Absolutely.
You have that tool in your arsenal, whereas you may not have that.
Well, we as attorneys can always try to settle it also. We do a stipulation of settlement, and we do the same exact thing. If
And
one
you have to
party-
draw a letter too in the same way, no problem.
Yeah, we have to draw a stipulation of settlement up, and sometimes we deviate from the Child Support Standards
Yeah.
Act. Actually, pretty often
Rationale
we
for
do.
deviation.
If we can't agree on it, then we are going to just strictly apply the statute based on their income.
All right, another tough issue is, in my opinion, is the domestic violence issue, because a lot of, and I know this for a fact, there's a huge number of men who are removed from their house for false allegations. I don't know how often you've seen this. I have it just a couple of times, not too many.
In regards to mediation, there are some people that swear that domestic violence issue can't be mediated.
Right.
I'm under the impression that it depends. I had a few cases where there was an order of protection, but it wasn't based on physical, it was based on mental abuse and things like that. And they asked me if I could mediate it. I took a look at the order of protection. I had them both sign a waiver, and they actually mediated with them. The one couple, I made sure that she left, and he didn't leave till 20 minutes after she did.
Right,
It was very high conflict. I was able to resolve it. I was surprised. It was a very tough decision.
the only-
Another couple I did
yeah.
separate, and two different, where I only met with them separately, and I was able to mediate that case. So there are times that it can be done, but you got to be careful, I guess, depending on the situation. If they're living together, even more careful.
I don't know, I've had so many different classes on domestic violence, and I have so few cases with it in it. And then you say maybe, well, did I miss something? Is it invisible? But I don't think these couples were fighting. I just found one. It was difficult, and I handled it. And I handled it the same way you did. I separated them when I needed to. I had one come in and come after later, and
Absolutely, and you can do that.
ask her if she was all right. I had to double check with her all the time. But
And
she was
sometimes you don't
fine.
even get their answer there because they're afraid to tell you
Yeah.
what's really going on. So you can actually do a full caucus mediation where you just meet with them each separately, talk to them each separately, and just relay to the other one what they approve that they're allowing you to tell the other one, and you can actually mediate an agreement that way, and they never have to meet in the same one together.
I think the fact that people in an abusive relationship would actually agree to mediation is a huge step. I actually have a pretty high percentage of people, both men and women, that are in abusive situations, and usually there is no talking because the reasons for the abuse could be due to mental illness, could be due to use of drugs or alcohol,
yeah.
and it's something out there that's hard to control. If you're getting people to agree to it, that's amazing, and that's wonderful if they could come to some type of an agreement, because it is
Gotta
a
be careful
very, very
with it.
difficult situation. I always have to give people a plan on what to do in case things start escalating, a code word that they could say to the children so that they know to call 911 and leave the house or go to a neighbor's house. These are potentially very dangerous situations.
And you can never
And,
guarantee outcome here either.
No, you can't.
you can't guarantee the outcome. You
Yeah.
have to just think
Yeah.
about the safety of your clients. There are some people that, yes, they will call in a false report just to get the other spouse out of the house.
Unfortunately, it does work,
And
though.
it does work because the police have to err on the side of caution because there are a lot of bad
Don't
things
you think we should
happening.
be taking those cases out of a family court or Supreme Court situation? Don't you think they should be handled for their criminal aspects first? If you're going to
Well,
take a father away
sometimes-
from the kids
Sometimes they are. If the police come, they are going to criminal court for that order of protection. If they
before the
once they get arrested, it's going to criminal court for the order of protection.
Before- yeah.
If the person doesn't get arrested, if the other spouse calls it in the next day, they're not going to arrest them that day. Usually, it's going to be going to family court, or it'll be a family court situation, a family offense petition.
Okay. Let's say Sandra answer this question. Can an attorney be a part of a mediation process, and how do you feel about mediation attorneys being part of the mediation process?
An attorney can be part of the mediation process, not to do the actual mediation, but
Right.
to look over an agreement once it's done to see if it's fair, and the attorney would still meet with both parties to review the agreement, so we wouldn't be representing either one. In the best case scenarios, if
You
they
can
come
do
to
that?
an
You can do-
agreement,
yeah.
and the attorney can look over the
Oh,
agreement.
one attorney called for both. What if they both have attorneys?
Well, they could do that also. There are mediation-friendly attorneys.
They could also, right, they could also, if they're not on the same side, if they're not in a complete agreement, then and you're not just looking over the agreement to see if it's fair to both of them, then you
It
would
must
have
be
a
hard for
separate
you to do.
attorney.
You're hired to, generally speaking, to zealously protect your client. Here you wanted a mediation process.
Well, generally you don't
Well-
have the one attorney do that. At least in my practice.
Yeah, my practice. I've
You
seen
would
only
just-
two.
yeah, sometimes it's just to
Sometimes
review
not.
an agreement. If they want to see if it's fair to them, you're meeting with them separately. But I've had cases where a mediator, for example, has done a postnuptial agreement, and with the postnuptial agreement, both of them are agreeing to do it. You're just looking over the agreement
Right.
to go over with them to make sure they understand it, and that's it. You're not really representing one or the other. They both have the right to go to separate attorneys to see if there's anything separate they want to go in, but if it's just for a matter of reviewing an agreement.
And in regards to the mediation process, I always let them know in the beginning that they're free to have lawyers during the process if they want to, that they can consult during the mediation. Because somebody say, well, what am I entitled to? Is that right? They could do that, and couples have done that. And it's highly recommended they both have their separate attorneys look at the agreement that I prepare for them. And some choose to do that, some don't. So it's up to the couple. But there are
And it's
mediation-friendly attorneys out there.
You know, it's always best for them to each have their own attorney look over the agreement, because the agreement could be invalidated if one person says, this one had an attorney and I didn't have an attorney, and I didn't understand what I was agreeing to.
That's unfortunately an issue for us to sometimes too. I like to try to have a review attorney review for both, whenever possible.
I use a review attorney.
Yeah.
After I do the agreement, my review attorney reviews everything, and then before I present it to the couple. So it's just an extra step that I do, because most couples will waive that right, because the whole reason they're in a mediation is because they want to save money. It's just like the same thing with evaluating quadros.
And that's what I was
things like that. They
referring
don't wanna
to
pay
when
for
I
it.
said reviewing the agreement. So yeah,
Right.
that would be the one attorney, but if they want to have it reviewed to see if it's fair to them, they would each have to have their own
In a
attorney.
final minute here, this child dysfunction is growing, as I had mentioned in the opening. It's a very serious issue. And it seems to be far more prevalent in a litigated divorce as opposed to the mediated divorce. They seem to have less issues with the children, about 24 seconds each year. Go ahead, give me a response to that.
Okay, you're saying, I'm sorry.
That's okay. There seems to be more child dysfunction coming out of litigated divorces.
Yes. Okay. Yes, that is because a lot of times what happens is parents talk in front of the children about what's going on in the
The
case,
alienation
and
thing?
they get them
Yeah.
involved in the case. Even unwittingly, it could just be talking on the phone with the attorney, with the child present. It could be saying something bad about the other parent. If he was giving more money, then it would be, we'd have more, and that puts the children in the middle. It puts them in a difficult situation.
Okay, Sandra, thank you.
And like
Go
what
ahead.
Sandra said, because of the contention, you have two sides. People aren't talking together. I go over the Children's Bill of Rights and what they should do, and don't use the children against each other. And that's something where you have them all together, and they realize that these are things they shouldn't do. So you're more likely to have less issues with the children in a mediated divorce. But nothing's 100% either way.
You guys did a great job covering the roles of mediators and lawyers. I thank you very much, Sandra Radna, and of course Jeffrey Bloom. Thank you very much for you too. I appreciate that.
Thank you.
Thank you.
Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. And at FIT, we bring it to your TV, of course, every single week. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.